Hi, Ed. You have Keith Banner here.
Anyone else on the line? Eric?
Morning, Ed. Eric Mitnick as well.
Okay, so we are now on the record. We have Keith and Eric. Why don't you just make your actual appearances and then mute your lines unless you have a question.
Okay, Keith Patrick Banner, Greenberg Glusker for 660 BVD, secure creditor.
Eric Mitnick on behalf of Michael John Patterson and Wheatstrong Enterprises creditors.
Okay. And Julie, can I get your appearance?
Julie Villalobos on behalf of the debtor, Ultimate Brands.
And sir, can I get your name?
Scott Griffiths on behalf of Ultimate Brands.
Okay. Can you raise your right hand, please?
Yes.
You solemnly swear you'll tell the whole truth and nothing but the truth, so help you God.
I will do my best, yes.
Okay. If you don't understand a question or don't know the answer, then let us know.
Okay.
Our goal here is to get good information, not guesses.
Okay.
So I'd like to start out by, anybody else want to make an appearance?
Sure. Yeah. This is Jeremy Rothstein of G&B Law for the unofficial committee of franchisees.
I don't you can just say this today's date and the hearing date and name the case and case number, so we have it on the.
This is Monday, August 12th. It's about 10 minutes after 10. This is in the Ultimate Brands Chapter 11 Bankruptcy, case number 819 BK 12516. My name is Ed Hayes, an attorney representing the Chapter 11 trustee Richard Marshak. And with that, I know that we've already had extensive 341A before that lasted several hours. This one is not going to last nearly as long because we have the benefit of all of the previous questions and answers. Mm-hmm. I'd like to focus primarily on, or to start, I should say, with the secured creditor claims. And do you know what I mean when I say secured creditor, Mr. Griffith?
I believe I do.
Okay. Who are the debtor's secured creditors?
Is that a question to me?
Yes.
Well, I believe that Mr. Carpenter, although there's a question, may be a secured creditor. Maxim Financial is a secured creditor. There's the Happy Rock is a secured creditor. I may be a secured creditor. I don't know if a former landlord is a secured creditor or not. I don't think so.
He's talking about a judgment lien.
Certainly taxes, the government would be a secured creditor. Julie, I think that's the best of the list as I know it.
Okay, and I think you listed 5, and the amended schedules, I think, have 3. So let's start with the first one. And you had said Mr. Carpenter, would that be the 660 BVD LLC creditor?
That is correct.
And that would be Mr. Carpenter's entity, to the best of your knowledge?
That is correct.
Okay. And can you tell us how that debt came about?
Well, Mr. Carpenter and myself were both guarantors to the bank. Mr. Carpenter was a paid fiduciary advisor to the company with stock, and each of us guaranteed a loan to, at the time, was the Community Bank of Santa Barbara. The bank was sold twice, ultimately became the Bank of the Sierra. The original line of credit was termed out for 2 years with a balloon payment at the end of 2018, December 31st, 2018. Mr. Carpenter was responsible for the banking relationship, maintaining the banking relationship, as well as looking at other options for new banking relationships. For reasons I still don't understand, the bank did not extend the term loan beyond December 31st, 2018. Mr. Carpenter, without my knowledge, set up a separate business entity for the purpose of purchasing the loan to essentially establish himself as the bank. Through my general counsel, we have disputed that claim. I don't dispute that there is debt. We have disputed through a legal process is that Mr. Carpenter cannot be a shareholder or a paid fiduciary advisor and the bank at the same time. So we certainly want to get Mr. Carpenter paid back, but we just argue that he is not the bank.
When you say Mr. Carpenter was a paid advisor, what pay was he provided and over what period of time?
Mr. Carpenter was an ongoing advisor, insider. He and I at one point were very, very close. I saw him as a mentor. He was very realistic about the risk. He requested to help mitigate his risks for the initial portion of his guarantee on the line of credit. He received stock options. And then when the bank decided to take the balance that was due at the time, to term it out over 2 years, Mr. Carpenter requested and did receive stock options as compensation for additional risk. By the way, I also received stock options in the same amounts that Mr. Carpenter did, since we both assumed that we were each taking an equal amount of risk.
Was Mr. Carpenter ever paid money?
He was never paid cash.
When was the company formed?
The company was formed in August of 2008.
And when did Mr. Carpenter become involved?
Mr. Carpenter, after myself, was an early investor. I think his first investment, I don't know precisely. It could have been later in 2009. It could have been early 2010. And that was in the form of preferred shares.
When the bank did not extend the loan at the end of 2018, did it begin any kind of collection efforts prior to Mr. Carpenter buying the loan through his entity?
No. I had turned over everything regarding the banking relationship to Mr. Carpenter so that I could focus on other aspects of managing the business and trying to secure outside investors for the business. So it was kind of a division of labor.
But my question more specifically was, had the bank begun any collection efforts?
No.
Okay. Did you and Mr. Carpenter ever have any agreements or understanding as between yourselves as personal guarantors what would happen if either of you ever had to answer to or pay off the bank?
No. I think we both assumed, because Mr. Carpenter is a wealthy man and a pillar of the community in Santa Barbara, I think I can't speak for him, but I think he assumed that the bank would just naturally extend. The company was making great progress. They had a guaranteed loan, the deep pockets of Mr. Carpenter. I think we all just assumed that the bank would extend the loan. Mr. Carpenter and I had talked about finding another bank, and he had talked about other banking relationships to replace what was Santa Barbara, but now the Bank of the Sierra. If they did not extend the loan, that we would look for another bank. He would look for another bank.
But nothing specific ever in terms of
Never. No.
you two
No.
sharing that liability?
We just did not see that as an outcome.
Okay. To the best of your knowledge, did the bank have a blanket lien on all of the debtor's assets?
I believe that I never, to be honest with you, again, relying on Dave, I don't know the details of the bank loan, so I really can't speak to any of the details in the document.
Okay. And in the schedules, the amount of the claim is listed at about $517,000. Does that sound about accurate to you?
I question that because my recollection is at the end of 2018, and what our CPA has in showing that bank debt, it was listed as $468,000. Interest had been paid up through December 31st. So there's still a question as to the exact amount. Dave did have another unsecured loan of $60,000 that was never documented. We acknowledged it in our correspondence, and it's possible the 60 was connected to the 468. So there's some questions as to what the exact amount is of that bank loan.
Where did the $517,000 number come from?
I don't know. It's a mystery to me.
But it's in your schedule, so was it a demand or something that you
It's
received?
a demand, as I understand it.
Okay. The next secured creditor listed in the schedules is Centerpoint Group, that is described as a judgment lien from a lawsuit for the amount of approximately $97,000. Can you tell me what that was?
Yes, that was our corporate headquarters, and we had been negotiating with them to take a smaller space, and for reasons I don't really understand, that did not materialize. We do dispute the amount. We don't disagree that monies are owed. I believe the amounts that we're showing are closer to $60,000 in terms of rent.
So is this the rent on old office space?
That is correct.
How much time, was this future rent that had not yet come due, or was this past due rent that was not paid?
It was strictly past due rent that had not been paid. There was never any claim for future rent. I don't think.
The date in the schedules that says date debt was incurred is March 21, 2019. Do you know what that date is?
Are you referring still to the Centerpoint?
Correct.
The Centerpoint, we moved out of that space or gave up the space, I believe it was October 2018.
That's the date of the judgment lien.
Date, and when you say judgment lien, is that the notice of judgment lien on personal property filed with the Secretary of State? Or?
Yes.
Okay. And then the bankruptcy was filed in July?
June 28th.
June 28th, so more than 90 days later. What considerations did you think about in terms of the timing for when to file the bankruptcy?
If you would have asked me 4 months ago, would we need to file bankruptcy, I would have said no. We had talked to substantial investors that had a high level of interest. I think still do, some of them. The tipping point was we had an arbitration regarding M.J. Patterson, and we tried to in earnest work out some sort of settlement. Mr. Patterson was the most aggressive in his demands. At the time, we were not pursuing a counterclaim against Mr. Patterson. We had, releases with some of the other litigants in the past, small settlements. And so, given that the ultimate act of filing a chapter was looming or could loom, we had thought that cool heads would prevail. We were in discussions with counsel for Mr. Carpenter to work out some sort of modest payments as we were pursuing investor opportunities. The tipping point was that we could not find any reasonable way to make the Patterson issue go away. It actually became even more aggressive, and we started proceeding into the arbitration hearings. The costs were going through the roof, and even though everything else seemed manageable, the fact that Mr. Patterson, we couldn't find any comfort, and that was really the tipping point.
Give me the 2-minute version on what the Patterson arbitration was all about. What were the claims Patterson was raising?
Well, there are two components, or multiple components, to the issue. His claims are essentially there were mistakes we consider non-material in the FDD. This was 3 years after the fact, multiple commitments to continue to develop. We had allowed one of our franchisees to debrand. That was the tipping point for a number of franchisees that decided to stop paying royalties. But Mr. Patterson came back through his counsel claiming that because there were mistakes, their argument that these mistakes in the aggregate constituted fraud, and therefore he was entitled to get a lot of money. Our argument, we had a capable litigator that I think did an excellent job of debunking those claims. We have in black and white the opportunity. We know that Mr. Patterson did commit fraud, but it's not a gray area. It's not conjecture. And we would certainly, if necessary, like to proceed with that claim against Mr. Patterson. We set up a competing brand, competing network, and really the good franchisees single-handedly really hurt the good franchisees.
Did the arbitration actually go to decision?
No.
And do I understand correctly, the debtor was not raising its counterclaim, to use your word, against Mr. Patterson?
No, we felt that the cost of pursuing the counterclaim, and we believed that, again, cool heads would prevail, and that, we would leave the table with some sort of resolution.
So Patterson is not listed in the schedule of secured creditor claims. Do you have any understanding whether they have any kind of attachment lien or anything else that's prejudgment?
No.
The next creditor on the schedule is Maxim Commercial Capital, and can you tell me what that debt is?
Yes. Over the last 2 years, there was no new bank financing. There was no investor financing. The lender of last resort was essentially myself, and pursuing some very expensive debt. And Maxim is, I guess you would call him a hard money lender. So in order to keep the doors open, given that there were no other options, we engaged Maxim as a lender.
Is there a promissory note?
Yes.
And what's the face amount of the note?
The original amount of the note was $400,000, and the current balance is around $200,000.
Was $400,000 actually advanced to the debtor, or was
No,
it a smaller number?
These hard money lenders capture essentially all their fees up front. So the amount that was advanced to us was, I think, around $240,000, and it was a 4-year note.
Where did the $200,000 number come from that's in the schedules with regard to what's owed to Maxim?
That's the residual balance of the note.
But that's something you've seen on a statement from Maxim. You don't believe that they would contest that amount?
I think they would agree that that's pretty close. They may have legal fees and other incremental charges, but I believe the principal amount is right around $200,000. I haven't seen the exact amount lately.
And it says date debt incurred May 27, 2019. Is that approximately the date that you first received the advance of about $240,000?
2019?
That's what's listed.
No, it was almost 2 years ago that the note was consummated.
Schedules also say that this loan is cross-collateralized by your residence.
That is correct.
Normally I wouldn't ask these questions, but I need to get a sense in terms of, is there any equity in your residence that is actually securing this note? So let me start by asking, what's your residence worth?
I think the residence is worth around $1.2 million.
And then what debt exists against the residence, and in the order of priority, if you can?
We have the bank mortgage, which is in excess of $500,000. We have the Maxim, which is around $200,000. We have another personal loan and lien on the property of $210,000. There's certainly the question of, my share of the responsibility on the bank, the original bank note. So
You're talking about the one that Mr. Carpenter now owns?
I'm talking about the original which he purchased. If let's say the bank had foreclosed on us 50-50 and it was $468, then I would owe $230, and the bank had a lien. I don't know if they had a lien on the property, but I believe that there might be a lien on the property. So that's certainly the secured portion I assume the secured portion.
Let me stop you there for a second.
Sure.
The bank loan that Mr. Carpenter's entity purchased, you believe that your personal guarantee was collateralized by a deed of trust against your residence?
I don't know that. I don't know.
Okay.
I know there's a personal guarantee.
So a little over 500 to the first, Maxim's about 200 in second position.
I think Maximus in second position, and then another loan is in third position.
And when did that loan go on the property?
That was approximately a month ago.
And what was the funds used for?
We haven't been taking any salary, and through a friend, we took out a personal loan. And
Who's the friend?
the friend is named Pat Turnbull.
And how much money did Pat actually advance to you?
On a personal note, it was $210,000.
And you actually received 210.
That is correct.
And then how much of that money do you still have?
Not much, maybe 25,000.
And what was the rest used for?
It's gone into, some of it went to the benefit of Ultimate Brands, to pay leases and landlords. Some of it just for living expenses. Some of it, I don't know, I'd have to do, a breakdown, but at the time we were, pretty lawyers. So I'd have to do an analysis on it, but.
When you say lawyers, which lawyers are you referring to?
Our general counsel, John Dellis, we've had to cash flow. Our BK attorney, Julie here, we had to write her a check.
Did you write the check directly to Julie?
Yes.
To me directly? No.
No, I don't know what that means.
Did you fill out a check payable to Julie on your account?
No, from one of the businesses, we wrote a check to Julie's firm.
And so what you're saying is you took the money that you received individually, put some into the business wrote a check to Julie.
That is correct.
Were there any documents or agreements between you and the business with respect to these monies that you obtained from the Turnbull loan?
I've kept a spreadsheet schedule, but I haven't, I haven't prepared formal promissory notes. Again, at the time, we were just trying to survive, and it's only a little over a month ago that the decision to file BK presented itself.
In your mind, were these funds that you put into the business from the Turnbull loan loans to the business, or was it capital contributions?
They would be considered loans.
Are you married, sir?
I am.
And what is your spouse's name?
Her name is Loretta.
Same last name?
That is correct.
Did Loretta also sign the deeds of trust on the Maxim deed of trust against your residence and the Turnbull deed of trust against your residence?
On the Turnbull, yes. I don't know regarding the Maxim.
Is your residence in your individual names, or is it in some trust or some other entity?
It's in a family trust.
Is it a revocable trust?
I believe so.
I believe you also listed out potential taxes as secured claims. Is that Internal Revenue Service and Franchise Tax Board?
It's payroll tax related, would be for California as well as federal.
Have you seen any tax liens from either taxing agency? Piece of paper that says tax lien on it?
I believe I saw a document that said tax lien against Ultimate Brands. When those documents come, I turn them over to Cynthia Diaz, who is our CPA.
The schedules don't list the taxing agencies as secured creditors. So, Julie, do you have any insights on whether they're actually liens?
I had no knowledge that they were secured at all. So
Okay. So they may or may not be.
They filed a claim. I don't believe they filed it as secured, but I can
Okay.
check that.
Yeah, I guess we can as well.
Somewhere I have it here.
Mr. Griffiths, at the beginning when I asked you to list out secured creditors, I think there were 5, including the taxes. Have we covered all of the secured claims or potential secured claims, or are there any others that you can think of?
There was another that I recall called Happy Rock. They were a hard money lender, merchant cash advance. They have a relatively small residual balance in the $60,000 range, and but they are a secured creditor.
They're not listed in the schedules. Is there any reason for that?
Not
to your
that I
knowledge?
know of.
They're in Schedule F. I don't have any documentation to show that they are secured.
I have talked to that lender, made him aware, and I believe he was contacted by legal, and I told him that if you haven't seen the contact, I gave him the contact information for Julie's office.
How did you find Happy Rock?
Happy Rock, ironically, was actually recommended by one of our franchisees who ended up being our first debrander. And that's a gentleman, I use that word loosely, but a person named Irv Goldman recommended Happy Rock.
Do you know where Happy Rock is located?
New York, or New Jersey, I believe.
Do you know if the documents specify that New York or New Jersey law controls?
I believe it's controlled by New York law.
And how much money did Happy Rock actually advance to the debtor?
Well, they took out an existing loan and extended a new loan, and I believe this is a year and a half ago, in February of 2018, and the face amount of the note was $240, took out a previous note, and I think out of that we captured around $160,000 is what we captured in cash. I don't know the exact numbers, so I'm guessing, but that's my recollection.
How much was the note that got paid off?
I don't recall.
Do you have any sense whether the face amount of the note of $240 was approximately the sum total of the cash plus the paid off other note?
That is correct.
So it's not like the other one we talked about earlier where there's a $400,000 note and you only end up with $240 in your hands.
That is correct.
Okay. And was this merchant cash advance structured in a way where they were hitting the debtor's bank accounts on a daily basis?
They were doing an ACH withdrawal, which is not currently happening.
Did that stop because of the bankruptcy?
It stopped because of the bankruptcy and also because the account they were pulling from was closed.
How much money do you think the debtor paid to Happy Rock from the time the loan went into place up until the bankruptcy?
including the payoff on the original amount, or the previous amount.
Well, put aside the payment of the previous loan, because that's what resulted in the Happy Rock loan. But then if Happy Rock was, let's say, in for $240,000 between cash to you plus payment of the prior note, how much did it end up collecting back through the ACH withdrawals? Was it a number bigger or smaller than $240,000?
I believe the amount that we captured was in the $140,000, $160,000 range, and out of that, I believe over $100,000 has been paid back, and the residual balance is in the $60,000 range.
So let me just make sure I understand. If Happy Rock's in for $240,000 through cash plus payoff of the note, you think the total monies that they've recovered back are $100,000, or is it closer to $180,000 if they're still owed $60,000?
Well, if they paid off a previous amount, let's say it was $240,000, the residual is $60,000, then they would have been paid back $180,000.
Okay, so that math made more sense to me
I'm
than
sorry,
what I thought I heard the first time.
Question.
Yeah. Some of these lenders, sometimes the way that they structure it, they may have given you $240,000 and you may have already given them back $340,000, but yet they still are owed $60,000.
Right.
So you think the total cash back to them was around $180,000, leaving a balance of about $60,000.
That's correct. Similar to the max in the sense that there's a total amount, they take their finance charge up front, and then the rest is to pay the whole thing.
And then
The whole thing off.
this is not in the schedules either. Do you have any understanding about what their collateral is?
Their claim is, I believe they have a UCC filing.
On basically everything?
I believe so.
Okay. Do you have any understanding whether Happy Rock considers this a loan, or do they consider that they purchased a portion of your future receivables?
They believe that they tied up everything, including future receivables.
And do you believe that they think it's actually a loan? If the company goes out of business, are they still owed money, or do they sort of assume the risk because there are no future receivables? What's your understanding about that risk?
I can't answer that with precision other than my conversations with Rick Geller. And we did a lot of loans, paid them off over the years. For a kneecap breaker, we had a pretty good rapport. My conversations with him now is, I think he's just looking to settle for what he can get. But I can't describe from a legal standpoint what he feels his position is.
Were the funds that were taken with the ACH withdrawals, was that always somehow tied to the receivables of the business, or was there also potentially loan money from the Turnbull loan, for example, or the Maxim loan, for example, that were in the accounts?
No, the Happy Rock was always tied specifically to the business as the Maxim. The only one that I think where there would be some gray area and would require some reconciliation is the personal loan, because it required living expenses as well as monies to the benefit of the business.
So which account were the ACH withdrawals coming out of?
The structure of the ACH withdrawals for Happy Rock were coming out of, there was a designated Ultimate Brands account.
And what monies went into that account?
The monies would have gone into Ultimate Brands, and the monies coming out for the ACH withdrawals would have come out of.
My question is, what was the source of the funds that the debtor deposited into this designated account?
Well, we're talking about Happy Rock right now.
Correct. Yes.
I may not understand the question fully. They gave us a check, or they wired money.
My question is, Happy Rock is pulling money out through ACH withdrawals on a daily basis. Where did the money come from that went into that account?
They wired the money to the account.
Not Happy Rock. How did the debtor fund that account? Was that your
Oh,
operating account?
No, we had a designated account for the ACH withdrawal, so we took it out of the operating account.
So the debtor would fund the ACH account from operations.
Yes.
And then the operating account only had monies collected, like receivables, if you will, or were other funds such as the Maxim loan deposited into the operating account, and then arguably some of that money was transferred to the ACH account for purposes of making the payments.
If I understand the question, the wires would go into the operating account, whether it was Maxim or Happy Rock, and then from the operating account, monies would then be moved into account or accounts specifically for the ACH withdrawal.
So it's possible that the monies that went into the ACH account were from sources other than future receivables of the debtor, because it may have come from Maxim, it may have come from Turnbull, because it all got thrown into the operating account, and then you funded the operating account in order to make the payments to Happy Rock.
Yeah, it's convoluted.
No, it's fine.
Yeah.
I'm just I'm going to want to see the Happy Rock documents.
Right.
But if the documents specify that all they get is a portion of future receivables, but the reality is maybe they got something other than future receivables because you were funding that account from loans, that's what I'm trying to figure out.
They were not getting future receivables. They were getting money that was made available to account or accounts with the purpose of paying off the obligation.
All right. So,
Michael has a point of clarification. At the last 341 meeting, the testimony, as I understand it, is that when Centerpoint obtained their judgment lien in October 2018, the debtor no longer used its bank accounts, rather funded everything through the subsidiary UFI. You may want to follow up and see if my understanding is correct, or whether there's some other thing that occurred. That critical date would be when the Centerpoint got the judgment lien and started attaching accounts, and the debtor needed to essentially avoid that from happening.
Mr. Griffith, did you hear Mr. Hauser's comments?
I think I heard his
Okay.
comment.
And so when the schedules say that the Centerpoint debt was incurred March 21, 2019, and your counsel said that was the date of the judgment, did Centerpoint start attaching things pre-judgment through writs of attachment or otherwise?
I don't know the timing. We had multiple accounts for Ultimate Brands and Ultimate Franchises, and our Pacific Enterprise account for Ultimate Brands, I believe it was Ultimate Brands, it had to be Ultimate Brands because that's what the contract was dormant. That particular Ultimate Brands account did not have cash in it, and I think that's where a lien was filed against that specific account.
And was that in late 2018?
I don't recall seeing that lien until well into 2019.
So it could have been 2019.
Yes, I believe
Okay.
it was 2019.
So at some point in time, because of the judgment or otherwise, did Ultimate Brands basically stop using its own bank accounts?
No, Ultimate Brands had until we set up the DIP account with Wells Fargo. We had moved our Ultimate Brands account from Pacific Enterprise to Chase. So we had a Ultimate Brands account at Chase, but the notice of the lien was for essentially a dormant account that still resided at Pacific Enterprise Bank.
So from late 2018 through the bankruptcy filing, Ultimate Brands was conducting banking in its own name, but only at Chase Bank, not Pacific Enterprise.
That is correct.
And were all of the revenues collected by Ultimate Brands deposited into accounts in the name of Ultimate Brands?
We had back and forth because we had royalties, we had corporate stores, so some funds were going to the Ultimate Brands account, some into the Ultimate Franchise account, so it wasn't as structured as probably it should have been in terms of where monies were flowing. But all monies were used to the benefit of the business.
Or business or businesses?
Businesses.
So this word might be a little loaded, and I don't intend it to be that way. The money got commingled, if you will, to go towards whichever business needed some money.
That is correct.
Okay. Is Ultimate Franchises going to file bankruptcy?
It's essentially dormant, and it's a wholly owned subsidiary. We hope that's not necessary, given that there's nothing in the account.
Does it have debt?
No, it has no specific debt that I know of. I think all the debt resides primarily with Ultimate Brands.
Did Ultimate Franchises have debt during this 1-year period prior to bankruptcy when the monies weren't super structured that got paid off?
I don't recall any specific debt obligations in Ultimate Franchises. I could be wrong, but I don't recall that there was ever loans specifically to Ultimate Franchises.
What were Ultimate Franchises expenses typically?
Well, it was originally structured to be the franchise entity to collect the royalties, and then there were operating obligations for essentially managing the franchise relations, from marketing to field support, product sales. But with the corporate stores and the franchise stores, there was commingling, there was a lot of back and forth, but the original purpose of the structure was for the franchise-related activities.
Are the franchise agreements with the franchisees, do they list Ultimate Franchises as the franchisor or Ultimate Brands?
The contracts list Ultimate Franchises, but in the contracts it says those contracts can be assigned to any other entity without notice. So they were set up to be in Ultimate Franchises with the flexibility of transferring those agreements anywhere else without notice.
And were the agreements in fact transferred?
The cash from the royalties to consolidate everything under Ultimate Brands, we did assign the royalties to be collected by Ultimate Brands as we were filing bankruptcy. As to the actual legal structure and the perception of the legal actions, I can't answer that with.
But it was your understanding and intent to have all of the contracts assigned from Ultimate Franchise to Ultimate Brands.
It was my understanding that the optimal benefit to the creditors was to have everything under one umbrella, to optimize, maximize the value of the estate. That was my understanding.
So the answer is yes. It was your understanding and intent to actually do the assignment, if you will, of the franchise documents from Ultimate Franchise to Ultimate Brands.
I had understand that that action was appropriate and necessary.
Okay, I just want to know, in your mind, did it happen?
I I'm sorry to be vague on this. I believe that's what happened. With additional scrutiny, there may be a different perception, but I believe that's what happened.
Okay. And it was your intent to try to make it happen?
It was my intent for everything to be under one umbrella. That was my intent, and that was a positive thing.
What percent of Ultimate Brands do you own, directly or indirectly, through yourself individually, the family trust, businesses, etc.?
I provided legal counsel recently with an updated cap table. So if you take Griffiths, my private business, my family trust, it's 66, 76, 83%.
Okay. And I've heard, I think you even said it earlier, that Mr. Carpenter owns 14%?
No, with dilution. Now, he does have preferred shares, but if you take on a consolidated, a fully diluted basis, Mr. Carpenter is at 7% as of today.
Okay. On the asset side, the schedules list accounts receivable at $1.2 million with doubtful or uncollectible amounts of $400,000 for a net of $800,000. But isn't most, if not all of that, more than 90 days old?
Not necessarily. You have different baskets. You have a basket of royalties that are past due and owed by active franchisees. We have accrued for royalties that are owed by those who are operating under another brand, illegally, in default, and we argue that those are assets of the estate and collectible to a degree. And then you have others that are in default that shut down legally or otherwise, and that there's some residual obligation. We believe that a significant portion of what we're representing is collectible.
Are franchise royalties 100% of what you've listed here as receivables?
Yes, franchise royalties. Now, in the contract, there is a personal guarantee with every franchise contract. So there's a guarantee by the business that was set up by the franchisee, as well as personal guarantees for the husband and the wife.
Typically, how long would it take the debtor to collect the receivables? Is this unusual for it to be over 90 days old?
We haven't, because of our financial constraints as well as human resource constraints, we have not issued the letters of default. So we don't see it as being over 90 days. We just see that we have not exercised our legal rights to collect on an obligation.
Why was that not done if the debtor was running out of cash and having to file bankruptcy?
The excuse is we've just been literally overwhelmed, and we've had to pick our battles.
If demands were made, do you think some or all of this would get paid?
I believe that there would be settlements given the quality of our claims and the cost of having to defend by a defendant, I think there would be an active recognition that paying something, having some type of settlement, is the smartest thing to do for the defendant.
In connection with one of the loans, you gave a deed of trust to secure the personal guarantee. Have any of these franchisees provided deeds of trust to collateralize their personal guarantees?
No.
Prior to the bankruptcy, had you had any negotiations or discussions about selling the business or the assets of the business?
Yes, we've talked to a number of investment groups about selling part or all of the business.
Were you getting close to a deal with any of them prior to the bankruptcy?
I would say with a number of parties that the level of interest was very high. The number one hurdle was the ongoing litigation. It was creating a level of discomfort that the...
With Patterson?
Well, there were a number of litigation issues. Patterson was the most aggressive, but just that there were, 9 between the landlords and various franchisees, that the degree of uncertainty, regarding the claims or even the settlement, or we just didn't know. We needed to get those off the table in order to consummate a sale.
Who did you think was the best candidate to buy the debtor?
Well, it's speculative, of course. There is a private equity firm that invested substantially into the boardroom, which is about a third of our size, or less than half our size, that likes the category, likes our business model. And if we did not have the litigation, I think we would have consummated a deal.
And what's your estimate of where the deal would have turned out dollar-wise?
I can't say. I think if we knew better what they paid for the boardroom, what they invested in the boardroom, I think that would give us a better benchmark.
So it sounds like if no dollars had been discussed, these potential purchasers were kind of in the early phases of negotiation?
Well, we've been talking to a number of franchisees that have a fair amount of wealth. I've talked to, we've had a gentleman that was referred by a top M&A attorney, Will Churchwad, who was working with us and had been in contact with a number of investors. I can't say the degree of interest because I relied on that person to have the conversations and discussions, but the feedback was there was high interest that the litigation weren't there.
Well, in bankruptcy, and you probably have heard some of this, there is a process by which you can sell assets or an entire business free and clear of the litigation and the creditor claims. So if you could actually pass title without lawsuits following the assets, what do you think all of this is worth, and who are the most promising people that the bankruptcy trustee should be talking to?
Well, I would refer the bankruptcy attorney, the trustee, to Brian Guadano, has been managing those contacts. I think he's probably the best person to talk to.
And the trustee's spoken to him several hours this past weekend. Anybody else?
No, I just, other people that I know, high net worth individuals, for their opinion. If there's an auction, would they be interested? I think it's early right now to, I heard numbers prior to the BK filing. I could give you that range, but I think it's pretty speculative.
The payroll taxes, are these, how past due are the taxes? Like what time periods are we talking about?
We have over a year worth of, we had used an outside payroll service called Avitas, and I believe as of April, May last year, we stopped working with them. We were making payroll directly, and I believe for just over a year, we have not been sending in the tax portion of the payroll, and that's been accruing.
The notice that I have from the IRS, they faxed the letter to the office, says March of 2018 to present. And then their claim came in at an estimated like 630,000, somewhere around there, but
We need to do further analysis on that because there's a business called Converge that we never had any part of, and somehow we got notice that we owed taxes for Converge, which is not true. And then there's also other fees, I think, in that equation. So I think the number I heard from Cynthia was in the 550 range is what she had accrued.
Avitas is listed in the schedules as being owed $70,000. Is that a number that you believe the debtor actually still owes Avitas?
No. There was a marketing agreement of about $50,000 that was canceled, and Avitas had not moved forward on that agreement. We don't believe that any of that is owed. And there was, I think, a residual of $20,000 that we would not dispute.
And I wasn't present in court when the court held hearings on these issues a week ago, but why was it that the debtor was using the cash revenues that may have constituted the collateral of one or more of these entities without first getting an agreement or court order?
Well, first of all, this is a question regarding cash collateral with Mr. Carpenter. Are you referring?
Just any of the secured lenders.
Well, Brian Guadagno had been in touch with Carpenter and had been basically managing everything related to cash collateral, and I believe it was all kosher and managed appropriately.
So, do I understand you that Brian was handling discussions regarding use of cash collateral?
That is correct.
But no agreement was actually reached up until that stipulation between the debtor and BVD got filed, right?
They had agreements to continue to use the cash, and then those agreements were temporary agreements. I don't know the details. Brian would be the best person to talk to.
Was Brian a paid advisor? What was his relationship, if you will, with the debtor?
We gave Brian a small retainer, and the intent was he had negotiated with one party for debtor in possession financing, and in the pro forma schedules, assuming that the DIP financing was coming in, that he would be paid out of the DIP financing.
Paid what?
We had him budgeted at $10,000 a month.
And he was not paid current at the moment of bankruptcy, is that correct?
He received $5,000, and that was after the BK filing. And we discussed it. The company didn't have the cash to pay him anything until there would be more cash available.
But was he actually owed for services rendered as of the day of bankruptcy?
No, he wasn't owed anything as of the date of bankruptcy.
So was he first hired after the bankruptcy, or was he just paid current as of the bankruptcy?
I don't know the exact answer to that in terms of timing. He had been working with us to help raise funds prior to the BK filing. So the amount of money that he was paid, and I think he's the person to talk to, he may tell you that that was for the services prior to the BK filing. I don't know exactly how that was structured.
But whatever he was owed, he got paid.
I believe what he was owed got paid, and
Okay.
again, he would have to.
Their agreement was signed the same day that we filed bankruptcy. So whether it was before or after, I don't know, but it was signed the same day. And as far as cash collateral, to be very frank with you, we didn't have the budget and the numbers that we needed to even draft that motion.
Okay.
So that
I just know that was one of the
No, I know.
what I've heard is that
And
was
here
one of the
you
primary
are.
motivating factors. And
So we literally had to work with Cynthia for weeks to even get the numbers, and then Brian was working on a projection moving forward, so we could even just come to the table with a negotiating amount for what we would need to use for cash collateral.
I think it's been stated, but this is my first time with many businesses dealing with issues of bankruptcy. But in hindsight, we can't fix the past, but we filed way too early. We should have spent another month. We thought that there was a firefight that we had to deal with, but we should have given it another 30 days before we filed. And we've been playing catch up. We're mostly caught up, but we were playing catch up for about 30 days.
what leases, if any, is the debtor currently under?
We have landlord leases in 5 locations where Ultimate Brands has a obligation.
And what facilities are those, or how do you refer to them? And
They're
what's
salons.
all 5?
Yes, they're all 5 are salons.
And were these month to month, or were there leases for some period of time?
They tend to be 10-year leases, and a number of leases we've been in for a year, 2 years.
I have copies of the lease agreements if you guys want them.
Are you personally liable as a guarantor on the leases?
No.
You mentioned it earlier, and the schedules list out a number of lawsuits or arbitrations and things that are ongoing. Who's representing the debtor in all of those different cases?
We've been using a firm called Delis Long, Delis, second word Long, out of Tustin.
And how much has the debtor paid to that law firm in the year before bankruptcy?
I think we've paid, since we retained them this year, I think we've paid them around $60,000.
And you only first retained them this year?
Yeah, we had another firm that wasn't working out, and we needed to find another firm that.
What was prior counsel?
The prior counsel was called Dylan Girardi out of Carlsbad.
And why was that not working out?
I don't know. I was relying on the firm. I really don't know. They were on a retainer, not to exceed. The charges started going up. I think they started off doing a good job, but I honestly don't know. And the evaluation of the current firm and the quality of the work that they did, they felt that the quality was subpar. I really don't know. When I discussed with Tim that we needed to part ways, I have so many firefights. I didn't really spend a lot of time trying to understand. It wasn't worth my time.
They're listed in schedules with $100,000 of fees owed, so
That was my
frankly,
next
it's a
question.
fee dispute.
Okay.
Well, we
They
would
move forward.
we would absolutely dispute anything that they claim. There are not good feelings towards that particular firm.
Was this an amount that slowly built up over a series of invoices, or was this just one huge invoice
No,
that caught you off guard?
it kept building and building, and I argued with Tim that it was exceeding what we had agreed to in terms of budgets. And Tim was fully aware of our financial constraints, and I feel strongly that he violated the attorney-client relationship.
And why do you say attorney-client relationship?
Because he was given a retainer budget not to exceed.
Is that actually written in the retainer agreement?
It's not in the retainer agreement, but it was in multiple meetings and email correspondence.
And was it an estimate, or was it actual not to exceed language? What's your understanding?
Well, my understanding was in order to manage the cost of litigation, which can be very expensive, and to manage our cash flows, Tim was made aware on multiple occasions that we simply couldn't afford to exceed a certain budget. And if we were going to exceed that budget, then I needed adequate communication in order to deal with that issue.
Was Julie the only bankruptcy attorney that you spoke to prior to the filing?
That is correct.
And during the 1 year period prior to bankruptcy, were debts paid off or payments made on account of debts of which you were also a personal guarantor? Perhaps Maxim?
Yeah, we continued to pay Maxim on a regular basis. There were some late payments, but we paid them.
Turnbull? It was only there
Turnbull's brand new, so.
But there may have been a payment or so.
I think we're paying her just interest right now.
But still, it was coming from the debtor, right?
It may come out of one of my other business. I think it's coming out of a personal business account. I don't think the debtor has been paying that interest.
I know where you're going to go with this one, Mr. Hayes, and pretty much everything is coming out of everywhere. So, I mean...
I'm not sure that's where I was going, but...
Yeah, I mean, the debtor, within 90 days of filing or 6 months of filing, to pin down exactly what they paid over $600 or who they paid, it's extremely difficult. It's like one pocket and another pocket and another pocket.
Turnbull has not been paid out of any of the business accounts other than my personal business account.
I guess, what debts of the business are you personally liable on? It's Maxim for one, correct?
That is correct.
Anyone else? I know you borrowed money from Turnbull, but is the debtor also
No,
a borrower? It's only you.
No, it's only me.
Yeah.
There's no, the business.
So
is
are
not-
there any other debts of which you are also personally liable?
I don't know, I don't think Happy Rock. I think the only one I'm personally liable on is Maxim. And then, Carpenter may be able to argue that there's an obligation there.
But not a lot of payments have been made, or no payments have been made in 2019 on account of that debt, right?
Carpenter?
Yeah.
No.
And the debtor was current to the bank through the end of 2018.
That is correct.
Okay. And then Maxim's been around for 2 years, and they were getting regular payments up until the bankruptcy.
They've been paid through August. Through June, July. So they're current.
But basically, they were no longer. Okay, got it.
I did speak with their attorney. His understanding is that he's paying, but they are 1 to 2 months behind post-filing.
I would debate that. They were paid through July. So the next payment is due in August.
All of the litigation that's listed, is Ultimate Brands the plaintiff on any of it, or is it all Ultimate Brands as defendant?
We have not filed, we have the right, but we have not filed as the plaintiff to make claims against the, right now we're the defendants, and but
And there's no cross complaints.
no, but we reserve the right. to
Understand.
cross-complain.
I'm just thinking in terms of the trustee now stepping into the shoes,
Right.
and what are we in charge of managing on a plaintiff side, if you will, because the
Correct.
automatic stay will freeze a lot of stuff vis-a-vis the
Right.
debtor as defendant, but not necessarily as plaintiff.
Currently, I don't know of anything as plaintiff.
Okay. Had any of the litigants sought relief from stay, Julie?
No.
I didn't see it on the docket, but thanks for clarifying. All right, it's 11:30, and I want to try to wrap this up by noon if possible. So, do either of you have questions you want to ask of the debtor that are sitting here in the room? We'll start with you guys first.
No questions.
Okay, no questions. Keith, Eric, any questions?
I had a couple questions, if you don't mind.
Sure, make your appearance.
Okay, Keith Patrick Banner of Greenberg Gloucester, representing 660 BVD LLC, secured creditor.
Go ahead.
Mr. Griffiths, can you hear me okay?
I can.
Okay. I apologize for asking questions via the phone, but if you cannot hear me, just please let me know. I only had a couple questions for you today.
Okay.
You indicated in your testimony that you were not aware, or that the bank relating to the loan that Mr. Carpenter through 660 BVD now owns, you indicated that there were no collection efforts made by the bank. Is that correct?
I know of no collection efforts made by the bank.
Okay. Recently, there was a reply that we filed in the case. It was docket number 55 on August 7, 2019. There's a declaration of Mr. Carpenter with regard to a letter which was attached as exhibit to a letter dated January 10, 2019 from the law firm Powell Slater LLP, which is addressed to Ultimate Brands, addressed to you, addressed to the debtor, care of you, addressed to Ultimate Franchises, care of you, addressed to Ultimate Brands, Inc., care of you, and then also to you personally at 30821 Seminole Place, Laguna Niguel, California. Do you recall receiving this letter?
I don't recall ever seeing that letter.
Okay, do you, on January 10th, 2019, did you live or work or otherwise reside at 30821 Seminole Place, Laguna Niguel, California, 92677?
Yes.
Okay, so according to this email on its face, it indicates that it was served via regular and certified mail to you, it looks like 4 separate times, one to you personally and one on 3 on behalf of the entities. This is
I don't recall ever seeing that. The only thing that I recall getting was being served on a lawsuit, which I turned over to Dellis Long. But other than that, I don't recall seeing any or reading any correspondence.
Okay, you indicate there was a 2-year term loan, and that loan was obtained in December 2016, correct?
That is correct.
Okay, and so according to your testimony today, it was a 2-year term loan, as I indicated. So that would mean by December 2018, that loan would have fully matured. Is that correct?
That is correct.
So, and there was no extension of that term or other amendment to the term. It stayed firm at December 2018, correct?
Do you want me to answer yes or no, or do you want some commentary?
No, just was it extended from December 2018? That's all I'm asking.
I found out, I believe in February, that the loan was not extended.
Okay, so if the loan was not extended in January 10th, 2019, when this letter is dated from the attorneys Powell and Slater, LLP, the loan would be in default because it's fully matured, correct?
I didn't know what had happened, the details of what had happened with the loan, because I was focused on other areas, and I was relying on Dave to manage everything with the bank and the transition. I was stunned when I learned that the loan had not been extended and that Dave had not found another resource to address the loan. So,
and that is your testimony, despite the fact that this letter from the law firm Powell Slater LLP was served on you in 4 different capacities via regular mail and certified.
My
mail,
testimony is I saw no letter. My testimony is when I was served with the legal complaint, I followed up with Dave with a letter to Dave expressing shock given our long relationship, and did not hear back from Dave, and I turned over the notice of the lawsuit. I turned that over to Dellis Long.
Okay, Mr. Griffiths, you are the you currently serve in the capacity as the president and CEO of Ultimate Brands, Ultimate Franchises, and 2 Ultimate Brands, correct?
Currently.
Has Mr. Carpenter ever served as an officer or director of any of those entities?
He's served as a paid advisor.
No, my question is, did Mr. Carpenter ever serve as an officer or director of any of those entities?
No.
Okay. All right, I have no further questions. Thank you.
Eric, do you have any questions?
I have no questions. Thank you.
Okay. Then we will continue today's meeting of creditors and not conclude it. I don't know the trustee's next available date, and so a notice will get filed and served. So people wanting to know the date will have to check the docket, but we'll get that done probably within a week. And we will go off the record. It's 11:36. Thank you, everybody.